The applicant is granted bail on the following conditions. The applicant is granted bail on the following conditions. The applicant shall deposit a cash bail of 2 million shillings in a court. Each of the sureties shall execute a non-cash bond of 10 million shillings. The applicant shall also deposit his passport with the deputy registrar of this court and shall not travel outside the jurisdiction of this court without the express permission of court. The applicant should also desist from threatening, interfering with or intimidating the complainant or the victim. If he does, the matter should be referred back to court for appropriate action. The applicant shall also report to the deputy registrar of the communal division every last Monday of each month, beginning on the 27th day of January 2025. I so order.
Most of like my lord.
Passport yo otekedwa nga kabakulizo nga tenateekwa olwaleero ereetebwe mu kooti akabakulizo akalala nti ebikolwa ebyokutiisatiisa oba okwesoomera complainant oba n'oyo agambibwa nti omutuusako obuzibu obwo oteekeddwa okubyewala. Singa kooti kinaazulibwa nga ogenze mu maaso n'oteekesa mu nkola eyo ebikuganyiddwa fayiro eno oba okusaba kuno kujja kukozesebwawo mu maaso ga kooti wabeerewo step ekolebwa endala singa kinaazulibwa nti okutiisatiisa abantu baabwe. N'akabakulizo akalala akasembeyo nti bw'onaaba ofulumye ojja kweyanjulanga wategerejeswa wa kooti eno, si kooti eno ababula kooti eno buli maada esembayo omwezi, era nga kino ogenda kikola okutandika ennaku z'omwezi nga 27 ogw'olwereberye omwaka ogujja 2025. Ebadde ensala ya kooti. Application number
Bautu. I appear jointly with Mr. Seleko Muhammad.
Applicant is here.
The applicant is in court. Hajji my lord, I also appear with Mr. Mpima Jamil, Kaluba Enoch,
Who is for the respondent?
My lord, the respondent.
Name?
My lord, for the record, Kamsime.
Pardon?
Kamsime Charlotte, my lord.
Kamusime. Kamusime.
Yes, my lord.
Charlotte.
I'm holding brief for
On a brief for a merit
Timothy, my lord.
for respondent.
For the respondent, we have Council Namugeni's Beda.
Hold on. Let's begin with this one. For the applicant again, Mr. Who?
My lord, Robert Bautu. I appear jointly with Mr. Seleko Mohammed.
What's the spelling of Bautu?
B-A-U-T-U, my lord.
Then
Seleko Muhammad. Not Muhammad, Muhammad. I've seen the record is spelling him as Muhammad. Then Mr. Mpima Jamil.
Mpima Jamil.
Kaluba Enoch.
Kaluba Enoch.
Kahiju Irene.
And?
Kahiju Irene.
Where? K what?
Kahinju.
And Kahinju.
Yes.
Irene. All of these are for the applicant.
For the applicant, together with Chirunda Farouk.
Where is Chirunda Farouk?
Is in court, my lord. Nantambi Umaira Asiat.
Chirunda Farouk. What is the spelling of Farouk?
It is F-A. L-U. K-U.
Okay. And where is?
Nantambi Umaira. Umaira. U-M-A-I-R-A-H.
Okay.
Asiat. And last, my lord, Awero Sara. Awero Sara. A-W-E-L-O. Awero Sara for the applicant.
This Umaira is also Asiat.
Yes, Asiat. A-S-Y-A-T.
Okay, then for the other side, those who are joining you on what? State
Yes,
brief?
watching brief, my lord.
Watching brief, sorry.
Namugeni Zubeda. She's in court, my lord. We have Namugera Sani. She's also in court. And we have Ansongobi Hakim. He's also
Hold on a bit. Namugenyi Zubeda. Where is?
Namugera Sania.
Namugerwa
Sania, my lord. Sania.
Sania. Yes.
We also have Ansongobi Hakim.
Ngobi Hakim.
Yes, my lord. They are all watching
Hakim.
this.
What's the spelling of Hakim?
H-A-K-I-M-U.
That is that?
In this part, there is in court, my lord.
Yes, I'm watching brief. Yeah, that one I can quote you. Who for the state is Kamusime.
Yes, my lord.
Kamusime. The complainant is what?
It's in court.
The complainant is also in the court. I've noted. Yeah, so now there has been a lot of procrastination in this matter because I was indisposed. I am still indisposed, but I am in a position to handle this matter for the time being. The applicant filed this application seeking to be released on bail pending the hearing and determination of the criminal case number 27 of 2024 on such terms and conditions that the court deems fit and just. The grounds of the application as contained in the affidavit in support of the application are here in the ruling. I will not repeat them. The grounds opposing the application are also here. I will not repeat them. Now we'll go to the consideration.
If I may,
Court is handling this matter. This is the consideration of court. Okay, can you please sit down? Before I delve into the merits of the application, I wish to address a few concerns raised by the respondent with regard to seeking leave to cross-examine the applicant and the contents of a letter addressed to me in respect of the proceedings of the second day of December 2024 before the Assistant Registrar of this court. When the matter first came up on the 18th day of November 2024, the court issued directives to the parties to file their written submissions and adjourned the matter wherein at the next hearing the proposed sureties would be identified and the oral highlights of the submissions, if any, would be made by the parties. At no point did the respondent indicate that he intended to cross-examine the applicant. The prayer to examine was therefore brought at the time when all parties had filed all their affidavits and submissions. Considering that application is proceed by way of affidavit evidence, and the respondent made a reply to the application, and the fact that the respondent did not indicate to the court at the earlier opportunity that he sought to cross-examine the applicant, the prayer cannot be allowed. We regard the proceedings of the 2nd of December 2024 before the Assistant Registrar and instructed the Registrar to receive the particulars of the sureties. It goes without saying that the particulars of the sureties were already on record, and the respondent had also already submitted his written objections to the said sureties by way of written submissions and affidavit. Bearing in mind that bail applications must be disposed of within 30 days of filing of the application, the directive to the land registrar was therefore to only record and identify the sureties whose particulars were already on record. The overall discretion in bail applications rests with the judge, and I shall determine this application based on the written submissions filed by both parties. I now move to determine the application and its merits while carefully considering the submissions filed by both parties. Where necessary, I shall refer to them in the course of consideration of the application. The law that governs bail in Uganda is contained in Article 23, 6A of the Constitution. Provides that where a person is arrested in respect of a criminal offense, he or she is entitled to apply to court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Bail therefore is granted at the discretion of the court, taking into account all the interests of the parties involved and the society as a whole. The court shall consider the following while determining an application for bail: that is, the gravity of the offense, the nature of the offense, antecedents of the applicant so far as they are known, the possibility of a substantial delay in the trial, the applicant's age, the physical and mental condition, the likelihood of the applicant to attend trial, the likelihood of the applicant to commit an offense while on bail, the likelihood of the applicant interfering with witnesses. The court further considers the safety of the applicant, the community, and the complainant. It also considers whether the applicant has a fixed place of abode within the jurisdiction of court, or whether the applicant is ordinarily resident outside Uganda. The court further considers whether the applicant has substantial sureties ready to undertake that the applicant complies with the conditions of bail. And the other considerations may be whether there are other charges pending against the applicant and whether the offense the applicant is charged with involved violence. See the guideline 13 of the Constitution Bail Guidelines, Practice Directives of 2022. The considerations for bail are therefore guided by following principles enshrined in the Constitution, which include the applicant's right to be presumed innocent, the applicant's right to liberty, the applicant's obligation to attend trial, and the need to balance the rights of the applicant and the interests of justice. In this case, the applicant is charged with the offense of aggravated defilement, contrary to the said sections of the Penal Code. There is no doubt that the offense is serious. However, the applicant still enjoys the presumption of innocence. The presumption of innocence is a cornerstone of our criminal justice system. The respondent largely based his objections on the fact that the applicant may interfere with the investigations or potential witnesses. The investigations or interfere with potential witnesses through undue influence or acts of retaliation. I agree with the respondent that in cases such as this that involve victims and complainants with close family ties, cases of interference may occur. However, these are allegations that have not been proved before court. In the case of Pangil versus Republic 1973 East Africa 282, it was held that if courts are simply to act on allegations, fears, or suspicion, then the sky is the limit, and one can envisage no occasion when bail would be granted whenever such allegations are made. Therefore, the allegations of intimidation and interference can only be proved by the respondent adduced evidence to that effect. The respondent submitted that the applicant lacks a fixed place of abode owing to his business engagements in Juba, South Sudan. A fixed place of abode is a critical factor in bail considerations as it ensures the accused's availability for trial. The applicant must therefore present precise information touching on his residence to mitigate the risk of any absconding. In his affidavit, the applicant stated that he has two places of residence, one at Bulenga, Chikaya A Zone in Wakiso, and the other in Ibweya, Kajans Town Council. He presented evidence from area chairperson to indicate that he has been a permanent resident at Bulenga, Wakiso for over 20 years. This, in my view, is sufficient to prove the applicant has a fixed place of abode within Uganda. As to the question of the dual residence between Uganda and South Sudan, this cause has power to restrict movement of an accused person to ensure that he is within the jurisdiction of court, and the court may issue any order to that effect. The respondent also opposed the application on the grounds that the applicant had not demonstrated any exceptional circumstances to warrant his release on bail. What amounts to exceptional circumstances cannot be exhausted, but guideline 14A and E of the bail guidelines provides that the advanced age and grave illness of the applicant may amount to exceptional circumstances. Demonstration of existence of exceptional circumstances in an application for bail is not mandatory, but may be justified in certain circumstances. It has been indicated in a medical report from Action Bay Prison dated the 16th of November that the applicant complained of severe gastric pain, vomiting, diarrhea, yellow eyes, and passing of melena stool. Upon examination by the prison medical superintendent, it was concluded that the applicant suffers from chronic gastritis with a high suspicion of peptic ulcer disease and has some intestinal tract bleeding. The report also indicates that the applicant suffers from mild anemia. This is a serious condition. I know that the report from prison is not clear as to whether or not the condition can be handled in prison facility. However, a mere demonstration that such condition exists may compel court to grant the applicant on heavy grounds. Rule 14A of the bail guidelines that deals with grave illnesses as exceptional circumstances does not take away the discretion of the court to grant bail on healthy grounds, since the provision merely provides guidance and not direction. Each case, however, must be determined on its own merits. With regard to the sureties, the respondent was opposed to their suitability on grounds that they had not clearly demonstrated that they understood their duties. The suitability of sureties is critical while handling bail applications. The court must be satisfied that the sureties presented by the applicant are substantial and capable of ensuring the applicant's compliance with bail complications. See Uganda vs. Chwanukandi, Chwanuka Chiza, criminal application number 2004. Rule 15 of the bail guideline provides certain considerations such as age, work and residence, character, and antecedents, relationship to the accused person, and any other factor that court may deem fit. Sub-rule 2 of Rule 15 also requires that the proposed sureties provide documentary proof, which includes a copy of a national ID or a passport or an introduction letter from the local council chairperson of the area where they are ordinarily residents. The applicant presented the following surety. The applicant presented the following sureties as indicated in his application. The first one was Mukasa Yusuf, aged 52 years old, resident of Murenga B, LC1, Mushale B, Sumwe Parish, a holder of an identity card in Nini Naura, which was reported as CM 720-99103M4FD, the director of Doctors Clinic in Murenga, businessman and a long-time friend of the applicant. Second applicant was Bamanya Aristo, aged 53 years, a resident of Rwanda B, local council 1, Maruga Ward, holder of NIN CM 1032-1045 N7L, an uncle to the applicant and a businessman in Matuga. Third applicant was Muheri Zadan, 47 years old, resident of Mutundwe 1, Rubaga Division, holder of NIN, that is a rent card, CM 7034100HP 0F, a vice chairperson of Mutunde 1 village, a businessman and long-time friend of the applicant. And the fourth was Luanga Siraje, aged 63 years, resident of Mutunde 1 village, Rubaga Division, holder of identity card NIN CM 610121041TMG, an imam of Mutundwe Mosque, a neighbor and a long-time friend to the applicant. Acting on my instruction, I directed the assistant registrar of this court to receive and verify the particulars of the proposed sureties. I have also since verified and confirmed the said particulars of the sureties and the documents presented in the court as required by the directive 15.2 of the bail guidelines. In considering their suitability, I have considered their age, relationship to the applicant's age, their status in society, their relationship to the applicant, may have known each other for a long time, find that the proposed sureties will be able to prevail over the applicant. Lastly, any risk of interference with the investigation was not proved by the respondent. Equally, there was no evidence to show that the safety of the victim and the complainant would be prejudiced by granting the applicant bail. The remaining allegation is the absence of any proof. In the result, the application succeeds.
Runesa Properties yifeba kabaka mukutunda amataka g'ebyapa n'ebibanja era nga tukuletedde estates ne properties enjawulo kwetola eggwanga lyonna ku ssente ez'owansi okutandikira kakadde kamu n'ekitundu okugeza Nakifu Makateete 25 ku 5 ku miliyoni 1.5 5 ku 10 ku miliyoni 6 Namalirika Kuukulu 5 ku 10 miliyoni 6 25 ku 5 ku miliyoni 1.5 tulina poloti ebugema okulira n'emabega wa university 5 ku 10 ku miliyoni 12 zokka na 5 ku 5 ku miliyoni 6 zokka nga kwoteka offices of Esangwa Kasangati ku 10 okulira na Equity Bank tukyalireko leero tukutuusa ku ttaka ly'ekirooto kyo ate ku bbeeyi layisi ate nga ku Runesa Properties tukuyambako n'okulakulanya ettaka lyo nga tukubira pulaani z'amayumba ez'omulembe kw'oteeka okuzimbira okumanya ebisingawo tukubire ku noti 774 12 07 10 ne ku noti 704 27 41 28 Runesa Properties, let's guide you home.